Welcome to meeting number 12 of the House of Commons Standing Committee on Citizenship and Immigration. Today's meeting is taking place in hybrid format, and I think we've got a few motions to start off with, but I think I'll just get started with just giving the introductory comments at first. I want to make a few comments for the benefits of our witnesses, and just always a reminder to our members as well. For those who are joining us on Zoom, kindly click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. And just a reminder for those on Zoom, at the bottom of your screen, you could select the appropriate channel for interpretation, either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. As always, kindly wait until I recognize you by name before speaking. I will remind everyone to kindly not speak over each other, as it will be very hard for our translators to translate, and it makes their jobs difficult. Of course, please ensure all of your comments are addressed through the chair. Members, please raise your hand if you wish to speak. The clerk and I will manage the speaking order for the best we can. I have sadly forgotten my red card and my yellow card today, but I will give you the 1 minute warning, and then I will let you know when your time is up and your microphone will turn off. Thanks in advance for your cooperation. And before we get into the standing order of today, I'm going to turn to Ms. Rempel-Garner. I think she's got a couple of motions to introduce.
Correct. Thank you, Chair. I'll begin with our housekeeping motion. I move that, notwithstanding the usual practices of the committee concerning access to and distribution of documents, up to 3 associate members of the committee per party be authorized to receive the notices of meetings and notices of motions and be granted access to the digital binder. B, that the associate members be designated by the offices of the whips of each recognized party and sent to the committee clerk. And C, that the provisions of this motion expire as of Monday, January 26, 2026, unless otherwise ordered.
Thank you, Ms. Rempel-Garner. I think we have, do we have anyone to speak to this motion? Okay. So I think we have unanimous support for this. Thank you, Ms. Rempel-Garner. On to the next one.
Thank you. Chair, I move that the committee invite the Minister of Immigration, Refugees and Citizenship to appear before the committee for 2 hours in relation to both the 2026 and 2028 Immigration Levels Plan and the supplementary estimates B 2025-2026, and that this meeting be held no later than Thursday, December 4th, 2025.
Thank you. Any comments, any questions? If none, do we have agreement? Yes, we have full agreement. Thank you, Ms. Rempel-Garner. That's very efficient. Thank you very much. So with that, pursuant to Standing Order 1082 and the motion adopted by the committee on October 23rd, 2025, the committee is resuming its study of subject matter of Bill C-12, an act respecting certain measures relating to the security of Canada's borders and the integrity of the Canadian immigration system, and respecting other related security measures. I would now like to warmly welcome the witnesses for our first panel. Joining us by Zoom, we have Debbie Douglas, the Executive Director of the Ontario Council of Agencies Serving Immigrants. And here in the room, we have Mark Weber, National President, Customs and Immigration Union from the Public Service Alliance of Canada. I'm going to ask Ms. Douglas if she could begin with an opening statement of up to 5 minutes, and then I will invite Mr. Weber to do the same. Okay, she just disconnected, so while we reconnect Ms. Douglas, we will start with Mr. Weber for 5 minutes. Thank you.
Thank you, Chair. Madam Chair, members of the committee, thank you for inviting me to appear as a witness as part of your study on Bill C-12. As National President of the Customs and Immigration Union, I'm happy to be here today to represent Canada's border personnel. I'm also appearing today on behalf of our umbrella union, the PSAC, Public Service Alliance of Canada. Per its name, Bill C-12 proposes a number of measures intended to strengthen Canada's border and immigration system. On paper, some of these measures are certainly very positive. Prime example of this language in the Customs Act that we see commercial operators need to provide border officers with access to facilities for both import and export inspections. The export aspect is currently lacking in the Act, and this is a commendable addition. In practice, the reality is that despite already having these powers for import inspections, The CBSA is rarely able to conduct these inspections when it comes to certain modes, such as rail, due to a now well-established lack of staff and a lack of facilities at which to do so. While the federal government has made it clear that hiring 1,000 additional officers was a priority and one we very much welcome, Bill C-12 therefore highlights once again how crucial adequate staffing is to a secure, well-functioning border. Adequate staffing also needs to be the cornerstone of well-oiled, secure, and fair immigration processes, including refugee claims. While Bill C-12 seeks to speed up the refugee claim process to address, I'll quote, lengthy processing times and backlogs, it is worth pointing out that without the sustained understaffing our border system has experienced for many years, these lengthy processing times and backlogs, and therefore the pressure to seek efficiencies, would likely be far less considerable than it is now. This is especially important in light of how CBSA has been managing the border for most of its history. Efficiencies as implemented by CBSA management almost always result in a degradation of the security and integrity of our border processes. We've seen it with traveler operations where people seeking entry to Canada do so through automated machines with no real interaction with officers. And outside of Bill C-12, we are already seeing it in some circumstances with the refugee claim process itself, where the agency's simplified intake process known as One Touch means claimants spend significantly less time meaningfully interacting with officers, with the result of reduced security for the sake of expediency. Interactions between officers and anyone who seeks to enter the country, be they travelers or refugee claimants, is a key component of border security. These interactions result in better intelligence and allow officers to recognize patterns and flags that would otherwise be missed, ensuring that any potential problem is detected early on and will not put further stress on the system at a later date. Crucially, experienced officers have the training necessary to navigate complex processes efficiently without compromising security. Yet, too often, CBSA prefers to push out experienced officers, as it is currently in the process of doing with nearly 200 officers who cannot carry a firearm, eroding both its institutional memory and its ability to maintain a direct contact with people transiting through our borders. The conclusion here is clear. Ensuring the security and integrity of our border and associated processes starts with an adequate human presence. Without this, without the human element, no bill can hope to truly solve border issues in the long term. I thank you for having me here today and look forward to your questions.
Thank you so much, Mr. Weber. That was excellent. It was less than 4 minutes, so thank you. I'm going to see whether Ms. Douglas happens to be available to be able to do her 5 minutes. You have to unmute yourself, Debbie. You have to unmute yourself, Ms. Douglas. Please unmute yourself. Kindly unmute yourself. Kindly unmute yourself. Kindly unmute yourself. Thank you. You've now unmuted yourself. If you could maybe
hello?
start from the top.
I'm not hearing you.
Can you start from the top, Debbie? You have 5 minutes.
I'm not hearing anything that's being said. That is truly unfortunate.
We can hear you.
There you are.
Yes, we can hear you. So if you want to just speak, you have 5 minutes, Ms. Douglas.
Oh, okay. I thought I had started.
No,
We're hearing
if you could start kindly,
That would be
we're ready for you.
great. Thank you very much. OCAC, Ontario Council of Agencies Serving Immigrants, is the umbrella organization for immigrant and refugee serving agencies in Ontario and now has over 250 member agencies across the province. We appreciate the opportunity to submit this brief to the Standing Committee on Citizenship and Immigration. This brief highlights our member agencies' concerns about potential impacts on the communities they serve. We want to draw attention to the possible negative impacts and unforeseen consequences of Bill C-12 on women and other survivors of gender-based violence, and disproportionate impact on Black and other racialized people and communities. These measures would weaken refugee protections, undermine charter rights, and contravene candidates.
Point d'ordre, Madame la Présidente.
Yes, point of.
Point of order. Unfortunately, interpretation is not possible right now. The connection is not good. Since we want to protect the health and safety of the staff here, unfortunately, we would have to interrupt this.
What do you recommend?
Si je peux me permettre, Madame la Présidente.
If you'll allow me, Madam Chair, whenever the health and safety of the staff in the House of Commons is in danger, unfortunately, we cannot go forward.
Asking the clerk to respond.
Mr. Giuseppe, right now the information I had is that the interpreters have the speaking notes of this person, so that probably helps them, at least for the initial presentation.
L'interprète me signale.
The interpreter says she can read the speech that was sent. Unfortunately, it will not be possible to go into questions and answers because we do not want any more acoustic shocks as we've seen in the past.
Maybe with that, we'll let Ms. Douglas finish her 5-minute remarks, since we do have the notes already. And then what I'll do is maybe when we're asking the question, Ms. Douglas, you'll probably have to just write down the questions and provide us the answers in written format, if that's okay. And then we'll have to get it translated, if that's okay with everyone. I don't know what else to propose at this point in time. Is that okay?
I'm sorry. That's fine, Madam Chair. What's the issue?
The issue is the sound connection. I think that when you did your test earlier this week, you were in a different location. We were able to hear you clearly. Where you're at right now, it's very difficult to hear you. We're able to finish your 5 minutes because we have your speaking notes, and so the interpreters now have those speaking notes. So I think all we can do right now is just hear you finish your 5 minutes, and then I'll have to ask you to maybe take down the questions, and then you'll have to take it down and respond to us in writing. I don't know any other way to be able to proceed.
Okay.
Okay, so if you could just continue with your 5 minutes, please.
Okay, should I start at the beginning or?
No, just continue from where you left off, please.
Okay. I wanted to say that this brief highlights our members' agencies' concerns about potential impacts on the communities they serve, and we want to draw attention to the possible impacts and unforeseen consequences of C-12. We have a number of key concerns. The first is the new ineligibility categories for refugee claimants. The bill introduces 2 new ineligibility provisions that prevent individuals from accessing an oral hearing before the Immigration and Refugee Board. And we know that persons who claim more than 1 year after the first entry in Canada for people who have been here since June 24th, 2020. And secondly, persons who claim more than 14 days after entering at the land border between ports of entry. Canada may return such people to countries where they may face persecution and risk to their safety, thus contradicting the non-refoulement principle. Individual circumstances may change and may present a new need for protection beyond the 1-year deadline imposed by C-12. This provision can disproportionately impact women, members of the 2S LGBTQI plus community, and other survivors of gender-based violence. It risks including people whose countries are facing political upheaval and war and who are not. 2, removal risk assessment. People who are excluded from making a refugee claim under the above 2 ineligibility provisions may be offered a PRA. The assessment is an administrative decision made by an IRC officer and lacks the procedural safeguards of a formal refugee hearing. Unlike the Immigration and Refugee Board, it provides no right to an oral hearing as required by the Supreme Court's CIMM decision, nor does it provide a right to resources or expertise to properly evaluate a claim. There is a very real risk that people in need of protection will be quickly deported only to face persecution and harm. Moratorium countries. Individuals from countries like Haiti, Afghanistan, and Venezuela, where Canada has suspended removals due to generalized. They're granted temporary presence, but denied fundamental rights and a pathway to permanent residency. Since a order which does not exist for this group, they are left in a perpetual state of uncertainty, fully participate in or contribute to powers to cancel documents, suspend, and terminate applications. The bill gives the government sweeping new powers to cancel for reasons of public interest, including permanent or temporary resident visas, work or study permits, to allow the government to suspend new applications in a specific category and suspend and terminate processing of applications already submitted as a matter of public interest. It can include applications for permanent or temporary residence or work or study permits. These measures will create gaps and unexpected problems for affected people and lead to more people living precariously, in compounding effect of cutting them off from rights and entitlements, access to services, and increase their vulnerability to exploitation and abuse by bad actors. These are broad provisions with no safeguards against the targeting and singling out of certain groups and potential unfair treatment and discrimination by the current or future governments. Several recent reports have highlighted the rise of racism and xenophobia against many different refugee and migrant groups, including international students from South Asia, specifically Indian students. This measure can potentially risk making these conditions worse. 5. Disclosure of personal information. The bill allows the government to disclose personal information within the Immigration Department and federal government, as well as to share with other orders of governments, agencies, and crown corporations and foreign entities. It witnessed the protection of refugees and immigrants' data by sharing information relating to their identity, status, or immigration documents, and could risk their safety if they are deported or when they must travel abroad. Thank you, and again, apologies for the bad sound.
Thank you so much, Ms. Douglas. I did give you a little extra time since I know that we were not going to be able to ask you any questions. I will make sure that your remarks are distributed to everyone on committee as well. And I too apologize for the sound issues, and particularly to our translators. Thank you for speaking so quickly. I know that that was very quickly done. Okay, so we're going to go into our first round of questions, which is for 6 minutes. Again, Ms. Douglas, sadly, I don't think that we will be able to have you answer any, but if you would like to I'm not quite sure how we'll do it. If there's questions for Ms. Douglas, maybe you could sort of just ask the questions, and we'll have Ms. Douglas write in her answers. We'll have it translated and hopefully get it to everyone by, if possible, end of day Wednesday. It's the best thing we could do. But for the rest, Mr. Weber, you are the man on the hot seat here, and I think there'll be many questions for you. And I think so for our first one, we have Mr. Redekop for 6 minutes.
Thank you, Madam Chair, and thank you to the witnesses today. Mr. Weber, in your testimony, you spoke about the one-touch system and talked about how there's little interaction with the human in that system. Are we talking about the machines that when I come across the border back from Canada, I put my stuff in there and is that what you're talking about, or is this something different?
Different system. Those would be PIC machines. For refugee claimants, when they arrive into the country, previously they used to get a full interview with an officer. Security screening was done there. That's changed to a system that's called One Touch. So essentially, we get tombstone data, we do some biometrics, and the claimant is then allowed into the country to complete their security screening and such on their own through the One Touch system. They have, I believe it's 45 days to submit that, meaning, in essence, to speed things up, because we are short-staffed, we're allowing people into the country without first doing that security screening.
Okay, hold on a second here. So you're saying that a refugee claimant coming to Canada goes to a machine and says, I want to be a refugee in Canada, hits a button, and they're in the country. Is that what you're saying?
Yeah, it's not a machine, it's an application. So the one-touch system, they're given instructions on how to use that. That connects directly with IRCC, and they're given that documentation to complete on their own once they're in the country. We're not doing that
So
upfront
basically,
with them
they
anymore.
take out their phone, theoretically, and they tap it a few times, and they are now in the country as a refugee accepted by our country.
Yes, we get some basic data from them, and again, we do the biometrics. Beyond that, they're doing that on their own, yes.
So no human interaction. Your members do not ask any questions, don't confirm anything. It's a free-for-all into the country that way?
Very little. I don't know if I'd use the term free-for-all, but for the most part, it's self-declaration on the claimant's part, yes.
And so from your perspective and your members' perspective, this is not a good thing?
This is a terrible thing. It's during the interview, and again, I spoke to it in my opening statement about human interaction. That's where we ask follow-up questions. That's where we establish whether there's coaching, whether it's a legitimate claim. That's how those files are built so they can be dealt with properly. Later, that's where we gain that intelligence, and that's currently been lost, not to mention that about 10% never complete the forms through One Touch. So you figure with about 100,000 claimants a year, that's about 10,000 people who are allowed into Canada who they disappear. Then it's our inland officers then have to find them and remove them, so you're adding additional burdens down the road.
So 10,000 potential false claimants coming into that system that have to be removed. Wow. So I guess would it make sense from your perspective if, thinking now maybe about an asylum claimant, when they appear at the border, they don't necessarily have to give a reason for why they want to claim asylum at that point. Is that true?
Not a full reason, no.
Do you think it would be helpful if they did have to make that statement right away?
I think, again, the devil's in the detail. The key is allowing us to do the interview, to get the full story and ask follow-up questions, to judge and provide the proper information so that it can be dealt with later to determine whether it's a legitimate claim or not. That's what we're trained to do, and that's currently the part specifically that's been lost.
What would you think about not only doing that, but actually having that kind of recorded so that it's clear what the answers were from the claimant? Would that be a helpful thing or not?
I think it could be, yes.
Is it technically something that could possibly be done?
Technically, yeah. I mean, given what we see can be done now, I think so, yes.
Interesting. When the government did Bill C-12, did they ask for your or your members' input on this?
No. They may have spoken with members. The CBSA may have spoken with members directly about some need, not that I know of, though. I was not spoken with.
In terms of, I read before you talked about, you testified at the Public Safety Committee a while back, and you said, and I quote, speaking about the culture of the senior leadership in the Government of Canada, you said, quote, they have chosen to focus entirely too much on the services part of its name at the expense of what should be its primary mission, ensuring the security of our border and protecting Canadian communities. I'm assuming you're talking about CBSA there.
Yes.
So, I think we agree with that. Roxham Road, if you look at that, CBSA and RCMP officers became welcomers. Do you believe that with the adoption of Bill C-12, the government is going to suddenly shift its general attitude away from servicing illegal border crossers to enforcing the law? Or do you believe that this legislation is just another gift to Donald Trump from Mark Carney?
1 minute.
Yeah, I mean, my belief aside, I'm here to provide testimony in the hopes that that focus now switches back to security over facilitation. I think technology is absolutely useful. We're not dinosaurs. We realize there's a place for that. But again, the technology that we see the CBSA putting in place is all about self-declaration. It's about the traveler. It's about the refugee claimant doing everything on their own because we simply don't have the staff to do the proper interviews and do what we did previously. We need to see that stop.
The government has consistently said that the United States is a safe third country. From your perspective, would you agree with that assessment?
I think that is worth monitoring closely as time goes on.
Do you think that other Western democracies could also be considered safe third countries, European countries, things like that, places like that?
Again, not something that CIU has analyzed or put any research into. If you're asking me as Mark Weber, I would say most likely yes.
Thank you so much. Thank you, Mr. Weber. Thank you, Mr. Redekop. Our next Our next person for 6 minutes is Ms. Sodi, please.
Okay, thank you, Madam Chair. And thank you, Mr. Weber and Ms. Douglas, for being here today. My first question is to you, Mr. Weber. The federal government recently announced the hiring of 1,000 additional CBSA officers, which you mentioned in your opening statement as well, and also 1,000 additional RCMP officers with funding allocated for all purposes, hiring, training, deployment. How do you think this initiative will support the work that your members do on the front lines, and how will these additional officers improve the integrity of our immigration system?
Yeah, thank you. 1,000 is a great start. We estimate we're short between 2,000 and 3,000, but again, you have to start somewhere. You have to start training them somewhere. Our training program is 18 weeks with essentially a one-year apprenticeship to be a full FB3 BSO. So that's a lot of work to get those numbers up. We have concerns around our facilities and how many people we could train a year, given that attrition is about 600. We could train a maximum of just under 700 a year, so we're looking at having that added as well. We need the facilities to be able to train people to get those numbers up. But the 1,000 is absolutely welcome and will be a tremendous help, yes.
Thank you for your answer. My next question is that Bill C-12 will enact legislative changes that would allow CBSA to better respond to the needs and pressures of the asylum system. Are you able to outline what tools this legislation would unlock for officers in the field and how these tools will help stabilize and secure the asylum system?
So I know there's curbs on when claims can be made, greater information sharing. Again, the devil's really in the detail. We don't know specifically what information that is that's going to be shared. Is it information that's useful for us? What are we getting from IRCC? What is being provided by the RCMP and back and forth? None of that's been worked out yet. So it's really hard in terms of the information to answer that. But the additional staff, if it's allocated properly to the front line, focused on security, that will absolutely be a big help, yes.
Okay. Perfect. You've also stated with the introduction of this legislation, the federal government is highlighting its willingness to tackle border issues head on. What specific border challenges were you referring to when you said that, and how does Bill C-12 help to address some of these challenges or issues?
The additional resources in terms of staff, the additional 1,000 officers is really what I'm referring to. And again, though, I mean, I'm here because I need the CBSA as much as the Government of Canada to hear and understand that we need to get our focus back on interdiction. It's been entirely about facilitation for far too long. We see self-declaration like the machines were described earlier at our airports. We see plans for that at land borders. We seem to have a system where we're waiting for people who are here for ill intent to declare to us voluntarily that they are here for ill intent. We're still waiting. That's never happened and never will. Most travelers are here legitimately. Most claimants are here legitimately. Our job is to find the ones that aren't. And without the interaction with the traveler or the claimant, we're simply not able to do that. So we want to see us get back to that.
Okay. My last question to you is, in addition to the measures in Bill C-12, are there any further resources, training programs, procedural improvements you would recommend to strengthen border security while supporting fair and consistent outcomes for asylum claimants?
Yeah, absolutely. I think, again, the initial interaction with the person coming in, that is key. That helps in both ways. It helps identify legitimate claims, and it helps identify concerns, and it helps build those files so when it's dealt with later, it is dealt with appropriately. That's currently missing. And again, the additional people, if the 1,000 are allocated properly, that'll help us be able to do that and hopefully get away from that kind of automated self-service system where, again, we're seeing about 10% who never even really follow up, who are in the country. I mean, we assume they're not here. We assume it's not a legitimate claim if they're not following up as they should. That's not necessarily even so. It's just 10% who essentially disappear into Canada somewhere. We don't know where.
Okay. Thank you, Mr. Weber. No further questions, Madam Chair.
All righty. Monsieur Brunel-Ducet.
Mr. Brunel-Ducet, you have 6 minutes. Thank you, Madam Chair, and I thank our witnesses. I'll just put question to Mr. Weber. Your union represents officers who receive frontline applications, the vast majority. It's a very broad question. Does C-12 facilitate or complicate the work of your officers the way it's drafted now?
If it's applied properly, I think it could be helpful. There's hope for it, yes.
Et
With the new requirements and the new powers in the legislation, should we believe that with the current staff, it will be possible to implement C-12?
Both in every mode and across the board. We talk about additional facilities to inspect exports. We have to get those facilities built. We have to get the people in place. We can't really do that now. And again, the focus on exports, there is a concern, and I hear it from our members, that a lot of this is really focused on hopeful tariff relief. We're trying to show that we're focusing on exports to hopefully get a break in terms of what's going on with the current regime in the United States. We've tried that. I don't know that there's any hope that any kind of appeasement is going to help. Really, we're here to keep Canadians safe. Our focus still has to be on imports. Right now, we're able to force importers to build facilities to do exams such as in rail, and we simply don't do it even though we're able to. So when we see adding the ability to force facilities to inspect exports, we can do it for imports. We're not doing it. Are we going to do it for exports? We really need to focus on keeping Canadians safe.
une de vos demandes,
One of your maybe not main, but one of your demands, it was mentioned in the media often, one of your demands was to allow your officers to move between borders. In C-12, is there anything improving that?
Powers for the Coast Guard to do that. Again, if it has to do with IRPA or the Customs Act, are we going to be involved in that? Right now, as far as we can see, no. And between ports of entry, we don't do that at all. It's our mandate. CBSA has just decided they're going to allow the RCMP to do it. RCMP are not overstaffed either. We're talking about thousands of kilometers where we already have officers sitting at the border who have the full legal mandate to do that work. If I'm working at a port of entry and I see someone a minute down the road crossing, I am not allowed to interdict even though I have the legal authority to do that. I have to call the RCMP, who may say, well, we can't send anyone, or someone could be there in 3 hours. That's not an acceptable answer. We have the mandate, the legal authority to do it. We want to do it. We're trained to do it. We have the equipment. We're tooled. We have the vehicles. We have everything in place to do it. And we're told not to. And for a minute, try to imagine what that does to the morale of our people working at the border.
c'est justifié ça?
Is that justified by the government? They don't want to give you that because of lack of training? Because your officers are already trained to patrol.
Trained, we have absolutely everything available to do it tomorrow if the will were there. But it's just not somehow.
Et pourquoi pensez-vous que le gouvernement...
And why do you think the government does not allow you to do this? Does it justify its position?
1932 that essentially gave that work over to the RCMP. I mean, that's prohibition area. That's a long time ago. I don't know what the reasoning was for that at the time. Times have changed. We see the provinces being organizing different combinations of provincial authorities, park rangers. It seems everyone is involved in this work except the one people who have the responsibility to do it, which is us.
Est-ce que l'alcool est encore prohibé aux États-Unis? Non.
Is alcohol still prohibited in the U.S.? No, I won't go there. But are you familiar with the 14-day rule? I don't want to put you on the spot here, but are you familiar with the third safe country? Do you think that in C-12, the amendments that are brought forward by the government in this bill as it stands will change things? Or do you think it's just superficial, since in any event these people can have a risk assessment?
And again, you know, I hate to sound like a broken record, but it depends on the application, right?
Est-ce que, selon vous, si...
In your opinion, if C-12 is implemented as drafted, will that improve the safety of your members in your union, or will it have no effect?
For our members, if applied properly and they're allowed to get back to the work of interdiction rather than facilitation, I think it could be of great help. But again, this is very overall and broad. It's the devil is in the detail, and we need to get back to doing those interviews and doing the interdiction that we were doing previously.
Est-ce que vous en avez parlé?
Have you discussed this with your members? This C-12? Is this discussed with your members?
Are very aware, very involved. Yeah, we've put it out there, and you know they're really able to get into the weeds of what needs to be done.
1 minute.
I have no expertise in terms of processing refugee claims. We have people, for example, who've worked at Roxham Road for a long time, who know it inside out and backwards. In my opinion, you always go to the people who do it to find out how to do it well. I think that's part of what's lacking in this process as well.
Oui, c'est 30 secondes.
You have 30 seconds late, but okay, very quickly. Your members' general impression, if you could tell the committee, what are people saying about C-12? Do they have an opinion, favorable or unfavorable?
Based on the hiring of 1,000 additional officers, absolutely.
Merci.
Thank you.
Prochaine, c'est
The next person.
for 5 minutes.
And thank you, Mr. Weber and Ms. Douglas, for appearing before us. Mr. Weber, you said something powerful in your speech, in your opening remarks to us. You used the words reduced security for the sake of expediency. That's very, very, very concerning. And then in response to some questions from my colleague, Mr. Redekop, did you say it takes 45 days for someone, after they get that initial one-touch system, where they basically, pass the biometrics and fill in a few things, they have 45 days to self-administer the rest of the questionnaire and respond?
That's correct.
And how many of those, in that period of time, were deemed inadmissible?
So inadmissibility is deemed later on in the process. Again, our goal at the border is to build the file to be able to, identify non-genuine claims, right? And right now we're kind of relying on people to self-declare that they're a non-genuine claim. That's unlikely.
And you don't have them in front of you. You can't speak to them. You're just giving you a document that says, no, I'm not a criminal. I'm a good person.
Yes.
And I'm coming into the country, so let me stay in the country. At a time when CBSA has testified before this committee that they're trying to find 30,000 people in Canada that need to leave the country that are not here at this time. I want to touch base with you about one other thing. You mentioned additional resources and getting more people. So I looked in the 406-page budget that the government put forth in Parliament for immigration, refugees, and citizens to see what's in there for immigration. And very much to my surprise, the very opening line written in only the one-page document on page 311 that deals with immigration, despite the massive problems we're having with the file in the country. The very opening line is to meet up to 15% in savings targets over 3 years. The IRCC is rationalizing programming and so forth. How do you see that affecting your members?
I mean, our members are not IRCC. I have a lot of sympathy, and our members do too, for what they go through. The one-touch system I described, essentially when claimants complete that goes directly to IRCC. That's out of our hands, and they're given all that additional work while we, talk about massive cuts.
But you're doing really important work, and your work is, ensuring that the people that come into this country are safe to walk around in our communities. But you're being hampered because you don't have the resources to do that. They put in a system that, as you say, reduces security, but is more expedient. Canadians have an expectation that the people that are allowed into the country are safe to walk around in our streets, in our communities, around our schools, around our community centers. So it's shocking that committed officers with conviction, your members, who want to make sure that the border is as safe as possible, don't have the right tools to be able to do that. Now, you also mentioned about the morale, so I want to ask you that about that. How are your members dealing with the strain of having, 300,000 pending asylum claims on top of what they're dealing with every day?
Yeah, that's a heavy load to carry. We score last in the Public Service Employee Survey. We were in the last one. Occasionally we get up to second to last, but we're fairly regularly down at the bottom. I think this is part of it. I think management culture where management does not come from the ranks, where you have people making decisions who never worked at a border, who've never worn a uniform, who don't understand, again, the details of how any of these processes work. That's a big issue. I think how our accommodated officers are dealt with. I mentioned it briefly in my opening statement. Currently, we have about 200 accommodated officers, and I say accommodated, they can do almost the full job, except they cannot carry the firearm for injury. Some were injured during use of force training. CBSA is having them look at forced medical retirement rather than taking them and using that expertise and that knowledge. We're talking mostly seasoned officers who would be able to do things like process these claimants rather than go through one touch. There was a pilot program in Niagara Falls where they had accommodated officers do exactly this, and they were able to process faster than one touch was able to do it and give the full interview. Those are the kinds of things that we look to the CBSA to work on and to bring us back to interdiction rather than facilitation. And they don't. It's easier to treat your employees as a number who are disposable employees, right? That's how it's looked at.
That's very unfair. I assume that's it.
That is time. Thank you so much, Mr. Metagakis.
Thank you.
And thank you, Mr. Weber. Next, we have Mr. Fragiscatos for 5 minutes.
Thank you, Chair. Thank you, Mr. Weber, for being here. Can you speak more about the current situation with respect to resources in terms of personnel specifically, and also training? You made a point, I think, an important point, but it's nuanced regarding training. This government has committed to hiring more or putting the funding forward so that more personnel can be hired at the CBSA. But there's an important point about training that you had on the record, and I think that's important for us to hear again.
Yeah, thank you. The 1,000 additional officers is absolutely welcome, and it's a long time coming. And again, I thank the government for coming through with that. The training facilities we have now is one training center in Rigaud, Quebec. That could pump out just under 700 new recruits every year. Our attrition is around 600. So it's very difficult with only the one training center to really get our numbers up as quickly as we need to get them up. We have a secondary campus in Chilliwack. We've run some pilot projects through that, but it doesn't look like that is being used as it could. I know there was a location in Windsor that looked viable, but right now, despite what we bring forward, and we've tried to help the government and help the CBSA in locating places that they can use, it's just at Rigaud right now. So if we just stick with the current model, it's going to be a long, long time before we get up in 1,000 additional officers. So we really need to find somewhere to train them.
Okay, thank you very much. I don't see utility in dwelling on the past. However, it is important to understand where we've come from. Can you speak about previous cuts to CBSA? I'm talking about years back under the Harper government, the effect that had on CBSA, the challenges that posed for border security in general. Yeah, as a lesson learned, perhaps.
That was back during DRAP, I would say 2013-14. Very difficult. Again, that was a lot of frontline positions that were lost. I believe we looked around 1,200 total positions that were lost during that period. And we haven't really recovered from that. Those numbers stayed pretty much at what they were cut to for many years afterward. And of course, we've gotten busier. We've seen the influx of refugee claimants. We did not have Roxham Road. We didn't really have the inland offices that we have now. We have immigration holding centers now, too, that have to be staffed. So our needs have gotten greater, and our numbers have not gotten up from back in those years when we got cut. So it's been extremely difficult. So the 1,000 is very welcome.
Okay. Now something more concrete. We are looking at Bill C-12. Recommendations, 2 or 3 recommendations that you have for this committee on your understanding of C-12.
Again, review One Touch, start getting those interviews going, and start doing the screening before you're allowing people into the country, and allow us to use our skill and expertise to gather the intel, to find the people smugglers, to look for those indicators of coaching. That's what we used to do. I'd really like to see us get back to that. And overarching, I think, in whatever is applied from C-12, we need to make sure that the technology that's applied is used to help the human being who is having the interaction with the person who is coming into Canada, rather than putting technology in place to allow people to simply self-declare and hopefully at some point self-declare that they're here for no good.
On this one-touch point, and I understand everything you've shared so far, but there are other democracies that are using this system. Can you speak to that and how that compares with Canada?
I can't, no. I'm not sure exactly how their systems work. I know there's technology that's used in other countries. I mean, I've flown into the U.S. You see the biometrics and such. In certain aspects, they have more in place than we do. But when I do go, for example, to the United States, one of the things I do see is officers interacting and speaking to travelers as they come through. We've almost completely gotten rid of that at the CBSA, and that's partly staffing, but that's also partly focus. We've become really focused on facilitation and an attitude of, oh, well, it's fine, they self-declared at the pick machine.
Yeah, for the purposes of the record, I'll just note to colleagues, it's the European Union and specifically Germany that's noted that is using systems quite similar to this. So this is for our understanding as a committee, and I just refer that to analysts as well. That's all through, Madam Chair. Thank you very much.
That's time. Thank you. Monsieur Brunel-Duceppe.
2.5 minutes, Mr. Brunel-Duceppe. Thank you, Madam Chair. Some people on both sides of the border that defend immigrants are saying that in early February 2026, there's a risk that there will be an influx of migrants that's much larger than usual because of U.S. policies about visas, particularly for Haitians. Are you prepared for that? Will C-12 help you be prepared for that? Will the officers have more powers? And I know this is many questions, but I only have 2.5 minutes. Some say that C-12 won't pass the court test. We'll end up with the courts before C-12 is implemented. What will that mean for early February?
Not happen. In terms of personnel, again, there's no way that we're going to get 1,000 new officers trained and ready and in place by February, so that's going to be all hands on deck, a lot of overtime in a difficult situation once again. And again, that speaks to the difficult position that the CBSA is in with their current staffing levels when you look at systems like One Touch and something like you're describing and what's happened at Roxham Road and the numbers that we're dealing with the staff that we have. I mean, from the outside, someone who is less concerned with security, you could see where a system like One Touch is very attractive.
Et par rapport aux personnes.
When it comes to people who do the same job as you in the U.S., do you have any links with the U.S. Union?
In terms of the specifics of how they do their jobs.
Donc, vous n'avez pas de discussion par.
So you don't have any talks about what's involved here. Some are telling us that these traffickers operate on both sides of the border, not only people who come here, there's people who enter the U.S. too. And that 14-day rule applies to both countries, and what we're hearing, perhaps you experience that too, is now they have some kind of package deal. They proposed crossing the border, but they hide people 14 days. Did you catch people that way, or you don't have powers to patrol the border?
They're past the border. That's the RCMP who deals with that. We're not given the authority to do any of that work whatsoever.
Et donc, logiquement.
So logically, if we were to increase the hours at the borders, and it's important to repeat that for the analysts, that would completely change things in terms of reaction. I'd like to hear your views once for that.
Instant, it would be welcome. Again, we're tool trained. We have the legal authority. Us and the RCMP are the only two agencies who actually have full legal authority under IRPA and the Customs Act. I've not heard an argument that makes sense to me yet as to why we don't do this work with them.
Okay. Okay, I just want to make sure everybody's okay. We're going to finish this round, and I think then we'll end this session, just because Mr. Weber has been very kind to be on the hot seat solely for about an hour. Okay, so next we have Mr. Redekop for 5 minutes, and then we're going to go to Ms. Sidhu for 5 minutes. Mr. Redekop.
Okay, thank you, Madam Chair. Mr. Weber, you just said something quite interesting. You're referring to One Touch, and you said, if you're not concerned about security, it's a great system or something to that effect. Who exactly, or what are you referring to there? Are you referring to a specific person, or?
No, not a specific person. I'm talking about a culture at the CBSA who, over the years, having to deal with the level of understaffing that they have, I believe organizationally has kind of become lazy. That is no longer really the focus. How do we keep this ship afloat given what we have? I think that's the mentality.
So to paraphrase, then you're saying that from your perspective, the culture that exists at CBSA, and I assume you're speaking of management culture there, is not focused primarily on security. So basically, the agency that is whose job it is, whose sole purpose in life is to keep our borders secure, is actually not overly concerned about security. That's kind of what you're saying?
I think that can be a challenge, yes. I think over time the focus has become more about facilitation. There's excellent managers who I speak with who contact the union about concerns that they have, who would love to get back to doing the kind of interviews and interdiction that they used to do, but realistically, I mean, they'll tell me who am I sending to do that, right?
Right. So, I mean, no doubt that you have very capable officers, and I'm sure there are management level people who are also very dedicated and wanting to do their job. I'm sure that's why you signed up for the job in the first place. But so what you're saying is basically coming from the government and into senior management levels, there's a culture that our job is to be more service oriented, customer service oriented, rather than security oriented. Is that fair?
Yeah, my experience at the CBSA and what I hear from my members is that there's nothing that's more frightening than a wait time. That always seems to be the focus. Keep it moving, keep the wait times down, keep it moving, keep the wait times down, get them out the door, go.
Wow. So basically, if you create a wait time, in other words, if you take a few extra minutes to do your job, that is viewed negatively from a management perspective.
It is. I've heard some pretty extreme stories about people who are, spoken to about taking too long, about going too far in the interview. I mean, that's everything that you're there for. I question what the 18 weeks training and the 1-year apprenticeship is for if I'm simply there to watch a machine allow people in.
Wow. So, okay, this just gets worse, I think, because you're basically saying that if an officer was to have some suspicions, let's say, and want to ask a few more questions, takes a little bit longer, they can actually be punished for something like that?
Never seen anyone punished for taking too long, but I think you're reminded that your coworkers are dealing with an extreme volume, and can we please keep the line moving?
Move it along.
In essence.
Move it along. You also used the word facilitation or facilitators. When you or your members decided that they wanted to become CBSA officers, were they thinking they were going to be facilitators, customer service people, serving drinks, or whatever this conjures up in your mind, I guess?
Yeah, we're not serving drinks yet.
Yet.
No, I mean, certainly not. It's a learning curve. I do meet with the recruits when they go through REGO, and you see the eagerness and everything that they want to do and why they get into the work. I guess I'm a bit of a Debbie Downer, in that I try to give them kind of a realistic picture of what they can expect when they get to their workplace. And it's a little bit disappointing that that has to be part of what they learn.
I have a Roxham Road question. So, as you said, the RCMP dealt with people at Roxham Road, and from what I understand, they were simply given a customs violation crossing that border, rather than something that a charge that could have been done under IRPA or something like that. Can you speak to that at all?
Yeah, I don't know any specifics around that. I'm sorry.
Are there certain charges under IRPA that should be leveled against somebody irregularly entering our country?
There are, yes.
Okay, and to your knowledge, you don't know if they were being applied at Roxham Road or not?
I couldn't speak to exactly what happened with the charges that were leveled there, no. Sorry.
So even today, it's the RCMP, not CBSA, that deals with irregular crossers?
Correct, yeah. RCMP, and they have different combinations of provincial authorities depending on the province that are doing that work as well.
Wow. Yeah. I don't know. I think I've heard enough.
Okay, thank you so much, Mr. Redekop. Thank you, Mr. Weber. I think we have Ms. Sodi next again. 5 minutes.
Thank you, Madam Chair, and thank you, Mr. Weber. I know it's been a long hour of questioning for you, but I once again just want to reiterate the staffing shortages that the CBSA has had, and you've spoken about it multiple times in the last recent years, and this is exactly why our government is committed to hiring 1,000 new CBSA officers, and I know you've mentioned that it's just a start. But it's to support the important work that your members do on their front lines. Can you once again tell us how the day-to-day operations of CBSA officers will improve through both the hiring of these new officers as well as the new tools that Bill C-12 introduces in terms of how your members are able to process asylum claims at points of entry, which have decreased about 30% in comparison to last year?
Yeah, thank you. So the 14 days should decrease some of the amount of work that they have to do in terms of facilities for examining exports. If those facilities are indeed built for us to be able to do it, that would be tremendous as well. Staffing will help as long as, again, the staff is allocated to the front line. We see at the CBSA an organization that is very management heavy. We have small armies of middle and lower level managers. We currently have a contest. I'd urge everyone to go visit our website where we have members send in the most outrageous ratio of manager to officer at our workplaces. I mean, some we have double as many superintendents as we have officers working the line. That has gotten absolutely out of hand and gotten worse every year at the CBSA. We have superintendents, chiefs, administrative superintendents, administrative chiefs at ports of entry with 2 people working with a lineup further than you can see. And that is not uncommon, and I see that every workplace that I go to. Anything above a BSO does not process a traveler. So that's really something on top of all of this that has to be looked at as well. The 1,000 will help, but I really urge the CBSA to apply it where it needs to be applied, and that is people who actually interact with the travelers and focus on the security of Canada.
Okay. And you've previously noted that outdated or manual processes can slow decision-making and increase pressure on CBSA officers. Do you believe that the modernization measures in Bill C-12 will offer improvements that would reduce bottlenecks and help your members work more efficiently?
Yeah, I think they could. Again, it's very difficult because there's no detail into how this is going to be implemented. So without that detail, it's a difficult question to ask. There's definitely a lot of positive in here. Our concerns are mostly around the implementation. How's that going to happen, and is that going to happen with a focus on the front line, with a focus on security, with a focus on getting back to actually speaking to travelers and looking to do interdiction, or will the focus around that be introducing more technology to allow people to further self-declare and really circumvent the people who are there to keep Canadians safe?
Mm-hmm. Do you have any recommendations in terms of the improvements in the modernization tools?
Yeah, use the people that you have in place, such as I mentioned, the accommodated officers, the 200 or some who can start assist and start doing the actual interviews with the refugee claimants and get back to that kind of system that we used to have going before it was completely self-serve. Make the focus working at ports of entry, again, on interacting with travelers coming through, speaking to travelers, not relying just on the machine. Reducing the numbers of middle managers we have to get those numbers up at the front line so we have the people to do those interviews. I don't need 6 people supervising 3 people working. That is crazy by any measure, and that's currently what we have.
Okay. And then my last question to you is that you've emphasized the importance of having timely and accurate information when dealing with complex or high-risk cases. Do you believe that the enhanced information sharing measures in Bill C-12 will improve frontline decision-making and the system's overall integrity?
It absolutely could if it's the information that our officers need. Again, the devil will be in the detail. What kind of information are we getting? Are we sharing and not receiving? And again, when we're looking at specifically with refugee claimants, we're not going to be asking for any of that information because that's all self-declared through a one-touch machine. Our interaction with the claimant coming through is getting some tombstone information, doing the biodata, fingerprints, that kind of thing, and off they go to self-declare and do all the paperwork on their own, which then goes directly to IRCC. So I'm not really sure in that milieu what information we could be getting that could help if we're not getting back to doing the actual screening up front when they arrive.
Thank you so much, Ms. Sodi. And I think that concludes our first panel and our first hour. So I want to say thanks to both of our witnesses, Ms. Douglas and Mr. Weber, especially you, Mr. Weber. You've been really on the hot seat. And I want to thank all my colleagues for their questions as well and for the overall testimony. I'm now going to suspend so that we could change panels and we could start our second one in hopefully 5 to 10 minutes. Thank you. Welcome back, everyone. I'm sure, I think that all of our witnesses thankfully are here in person. We don't have anyone on Zoom, so thank you for being here in person. I'm just going to say a few reminders, although I think all of you are quite seasoned witnesses. Kindly wait until I recognize you by name before speaking. All comments are addressed through the chair. And I'll give you a 1-minute warning, and then basically your time is off once it is completed. And so now I would like to warmly welcome our witnesses for our second panel. We have Professor Michael Barutunsky. How do you say it? Barutunsky. Welcome. We have Mario Bellissimo, lawyer, certified specialist from Bellissimo Law Group Professional Corporation. Welcome. And we have Azadeh Tamjidi, senior legal officer for the United Nations High Commissioner for Refugees. Warm welcome to all three of you. Each one of you will have 5 minutes to give opening remarks, after which we will delve into questions. Professor Barutunsky, you begin with 5 minutes. There you go, you're on.
Madam Chair, thank you for having given me this opportunity to speak before your committee.
Witnessed in the last few years what is arguably one of the country's biggest public policy failures this century. We've seen record numbers in various categories, including asylum seekers who don't even come from the typical refugee-producing states, issuing of visas that was super lenient, with consequences that we're still managing, and we still have 3 million temporary residents who are not all going to become permanent residents. Even the very pro-immigration former Prime Minister and his immigration minister admitted a year ago that various parts of the system were being abused and were out of control. So it's in this exceptional context that I believe the immigration-related parts of Bill C-12 should be evaluated. Extraordinary times require extraordinary measures. I'll jump right into the controversial parts of the bill. First, a few words on Part 8, which eliminates the 14-day exception. Canada needs to treat asylum seekers fairly and humanely, but we have to make sure the system isn't abused. It's logical to eliminate, at least in domestic law, the incoherent 14-day rule introduced in the amended version of the Safe Third Country Agreement 2 years ago. Claimants should return to the U.S. to make their case for asylum protection if the government considers that the U.S. is indeed safe for asylum seekers. If the migrants refuse to do that, it is not unreasonable for the government to decide that they should be returned to their country of origin, following a pre-removal risk assessment. The 14-day loophole remains in the treaty with the U.S., but it should be rendered ineffective, and the proposed amendment is a simple and elegant way of doing this. I'll continue with another amendment in Part 8, specifically the one-year deadline. The one-year filing deadline has existed in the U.S. since the 1990s. To some extent, harmonization is inevitable if we're going to seriously engage in continental cooperation. It's still somewhat controversial for Canada to adopt this rule, given how much it's been criticized by refugee advocates over the years. In the U.S., the one-year period is calculated from the date of an individual's last arrival. I don't understand why we're proposing to calculate the one-year period from the date of the first arrival. Why import this controversial new rule and make it even stricter? at the very least, a small compromise would be to calculate from the last arrival. Having said that, there is a larger issue that deserves more attention. The concept of réfugiés sur place, promoted by UNHCR for decades, shouldn't be dismissed so easily. It's the expression used to highlight changed circumstances in the home country while the migrant is residing in another country. I think you should suggest, the committee should suggest, the idea of inserting an explicit requirement to consider UNHCR's réfugiés sur place concept somehow alongside the risk, the pre-removal risk assessment. A few words now on Part 7 and the mass cancellation ability. There is little transparency, yet the decisions can have grave consequences. Perhaps some public debate and scrutiny could be encouraged by inserting an obligation to adopt some sort of declaration in Parliament, recognizing, for example, a specific crisis or a situation of massive fraud. In any case, I'd encourage the committee to think about a mechanism that creates parameters around the use of this new tool. But how would these powers actually be used? Would the government
1 minute.
really would the government really cancel visas or permits for entire groups? And then do what if the people don't leave voluntarily? Mass removals? You can change the law, but ultimately it depends on your willingness to actually remove those who are present unlawfully. Given the track record to date, it seems unlikely we do this or be effective at it. My last suggestion, why not look at the problem from the other end? If we're deploying carrots and sticks, then the approach in Part 7 is as if we're signaling that we might bring out the big stick. The other side of a strategy, the carrot, could be for the government to incentivize migrants to leave on their own. Perhaps this could be done by proposing financial aid to help them return home. And this could be combined with future eligibility for legal residence if they do leave on their own. Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you.
Barut Siski, thank you. Next, we have Mr. Bellissimo, 5 minutes.
Madam Chair, members of the committee, thank you for the opportunity to appear again today. Bill C-12, in my view, presents a meaningful opportunity to modernize Canada's immigration and refugee system while restoring balance, security, efficiency, and fairness. Its aims, integrity, transparency, and modernization are commendable, and measures such as removing the designated country of origin regime, expanding digital tools, and improving cross-agency cooperation are positive and long overdue. The committee, though, has received, as my co-panelists just mentioned, substantial testimony warning that certain provisions expand discretion without adequate safeguards, weakening parliamentary oversight, including the role of this committee. Undefined public interest cancellation powers are of particular concern. The 2012 federal skilled worker termination demonstrated the uncertainty such authorities can generate. The minister testified that public interest is deliberately undefined to preserve flexibility. And no doubt flexibility has value, but without limits, extraordinary powers risk becoming unconstitutional. Similar concerns arise with the ineligibility bars over delayed or trauma-affected claims. There's concerns with the expanded data sharing authorities and with provisions preventing proceedings unless claimants or persons concerned are physically in Canada. We recommend, as set out in our brief and the brief we put before CQ, that those provisions require further study. Now, even if ultimately upheld, implementing these clauses would require major operational changes. For example, many refugee failed claimants, apart from those from moratorium countries, to list one exception, the only remaining pathway would be the PRA, as we've heard. And it's a process not at present designed to replace IRB adjudication. To even approach fairness, PRA would require significant scaling, an independent unit, specialized training, and enhanced protection. The committee may wish to ask IRCC to produce current PRA volumes and processing times to evaluate whether the system could realistically absorb that shift. Recent actions have lowered intake, but Bill C-12's eligibility bars, in our view, will not produce lasting volume change, nor will broad cancellation powers. Canada has seen this cycle before. We've tried restrictive levers and short-term fixes only to see pressures reappear in different forms. The good news is that none of this is inevitable. Lasting modernization and security are achieved not through episodic cancellations or deterrence, but through transparent, predictable intake management across the entire immigration and refugee system. A flexible expression of interest framework could better align admissions with processing capacity and real-time reporting guided by labor market needs and absorptive indicators, including housing, healthcare, and francophone integration supported by modern digital tools. Even in rights-based streams, family, humanitarian, EOI principles can help not as selection tools, but to manage intake fairly and prevent backlogs. For refugees overseas, a more structured pre-registration process supplementing current UNHCR referrals would enable earlier identification of at-risk populations and orderly, data-informed movement planning and reduce reliance on dangerous irregular routes. For those already in Canada, the IRB could adopt an EOI-style management national scheduling model supported by C12's improved information sharing to link hearings to capacity throughout Canada and better identify vulnerable claimants more effectively, reducing adjournments and delays while improving fairness. Our recommendations offer practical ways to advance modernization while avoiding new legal or operational risks. Certain provisions are not suited to quick amendment in our view. To give full effect to the bill's aims, the committee may wish to recommend that complementary reforms reported and already explored here at CIMM be referred back for further study and broad consultation following CQ's review. With thoughtful revision that builds on the positive elements of Bill C-12, the legislation can modernize the system in a way that strengthens border security, protects fundamental rights, and enhances public confidence. Canada can achieve both security and fairness without compromise. Thank you, Madam Chair. I look forward to your questions.
Thank you, Mr. Bellissimo. You should be a politician. That's almost exactly 5 minutes. Okay, next we have Ms. Tamjidi. Please, 5 minutes.
Thank you very much, and thank you for this opportunity to appear before you today on Bill C-12. As UNHCR, the UN agency serving refugees and asylum seekers in 134 countries and territories, providing technical advice on building a strong asylum system is an integral part of our advisory role. As of June 2025, 117.3 million people were forced to flee their homes, with 71% being hosted by low to middle income countries. Closer to home, Canada, like many countries, has seen a rise in asylum claims amid increased global displacement. Ensuring a strong asylum system that can both quickly recognize those in need of protection and refuse those who do not meet the international definition of a refugee is an important goal of any asylum process. We recognize the challenges that this entails, but we fully believe that Canada can meet them in a way that ensures the right to seek asylum is protected. Regarding Bill C-12, UNHCR notes that many of the proposed changes depends on future regulatory amendments, and a full assessment will only be possible once the draft regulations are available. We welcome elements that reflect past UNHCR recommendations, such as streamlining eligibility processes and enabling earlier appointment of designated representatives for children and other vulnerable persons, both of which contribute to a stronger and more efficient asylum system. At this time, UNHCR would like to focus its comments and recommendations on the new ineligibility provisions. One of the main changes under the proposed bill is that individuals found ineligible under the two new provisions would receive a pre-removal risk assessment, or PRA. Like the Immigration Refugee Board, the IRB, the PRA could grant refugee or protected person status. It was originally designed to use prior to removal after someone has exhausted all their legal means in Canada, including a hearing before the IRB. However, if the PRA is used as a first assessment of an individual's asylum application, as this legislation proposes, it should incorporate safeguards to comply with international and domestic law. First, UNHCR recommends that a mandatory hearing be added to to ensure an individual's right to be heard. Second, We would recommend that those deemed ineligible under these new provisions have the right to a full appeal at the Refugee Appeal Division of the IRB, which would also stay their removal until the appeal is heard. This would minimize the risk of returning a person to a place where their life would be at risk if there was an error in the PRA decision, and increases overall system efficiency. The final recommendation is that individuals from countries that Canada does not deport to, so-called moratorium countries, be granted exceptions to the new ineligibilities. If the bill remains unchanged, when a person from a moratorium country like Afghanistan is deemed ineligible under one of these new provisions, they will not have their refugee application heard and their case will remain in limbo. These are typically strong asylum claims and they merit an opportunity to obtain refugee protection. Moreover, certain individuals should be exempt from the 1-year ineligibility bar, such as vulnerable persons, and when there is a change in circumstances. This would allow for the specialized tribunal, the IRB, to handle more complex claims. UNHCR has long supported Canada's refugee adjudication model and the IRB. At the same time, we recognize that finding ways to increase efficiencies while upholding access to fair procedures are legitimate objectives. We hope that Canada continues to be a champion for fast, fair, and efficient asylum systems and to lead in an environment when other countries are closing the door on the principle of asylum. We have seen firsthand how the 1951 Refugee Convention and asylum have saved millions of lives in the past 74 years. As this committee has heard, 61% of those who claim asylum in Canada are found to be refugees, meaning that they have fled dangerous situations that required Canada's protection. For this vital reason, UNHCR remains committed to working with the Canadian government and civil society to ensure that the new measures are implemented in a manner that provides protection to those who need it and builds a stronger system to face the challenges of the future. Thank you very much.
Thank you to all witnesses for the excellent testimony and for all the great recommendations. We are going to begin. Our first round is 6 minutes, and so we're going to begin with Mr. Ma for 6 minutes, please.
Thank you, Madam Chair. My questions will be addressed to Mr. Baruchewski. So in a June 2025 article, you've discussed a safe third country agreement component of what is now Bill C-12. You emphasize that harmonization of the Canadian system with the U.S. system is the only way to bring migration under control. Can you expand on this harmonization point for the committee? It's on.
Yeah. I can expand a little bit if you want. So what I was referring to is just the dynamics of regional approaches to refugee protection are such that we can't actually have partner states with widely different standards. That's the problem for Canada, to the extent that the U.S. is perceived as having lower standards and Canada is perceived as having higher standards. And so what I'm pointing at is that we have to think about this difficult situation where, because of geography and history, we're forced to cooperate with the U.S. and how to actually figure out a way to have standards that are relatively going towards harmonization is what I was trying to suggest.
And what impact would that have, do you see, for Canadian asylum seekers?
I think we had that sort of referred to in a sense from my colleagues, and a lot of the testimony you received is a risk of the standards in Canada dropping so low that they become they don't respect our charter obligations, for example. So that's the challenge for all of us, to figure out how to harmonize to some extent while preserving our specific approach, and we try and maintain relatively high standards. These issues are not unlike what the European Union has to go through, wide standards, and then the consequences of not harmonizing to some extent. There are consequences we have to think about, and that's a bit of the dynamic we're stuck in.
Thank you. I've also noticed on the Kosovo refugee crisis 1998 paper, and the UN High Commissioner for refugees' supervisory role, that burden sharing agreements is a recurring theme for solutions. Can you outline some of the best practices around burden sharing agreements, and especially as they apply to Canada's Safe Third Country Agreement, and how this can help bring our asylum numbers under control?
Right. So burden sharing or responsibility sharing, and that's what we're dealing with the U.S. We're trying to figure out, we're trying to avoid having asylum seekers make multiple claims. I mean, that's, I think, one of the motivating, the motivation behind this. And so it's related to your first question is, well, standards have to be somewhat similar, but we have to be confident that we can partner with another state, here the U.S., maybe other states as well. There is some testimony or some questioning exploring other states that Canada, I think, would inevitably have to partner with in terms of safe third country agreements. The idea is that can we agree on standards that are reasonable for all of us and then try to manage forced migration in that sense. I think we're, in a sense, forced to. This is not the nice side of international refugee protection, but the reality is that we're going to have to collaborate, and these responsibility sharing mechanisms are something we're inevitably going to have to look at more seriously in the future.
Okay, thank you. So you described that the federal failure broke Canada's asylum system in a January 2024 commentary published with the Macdonald Laureate. You also mentioned burden sharing scheme in this commentary as a solution path. So building upon that article, would you say Bill C-12 is doing enough to fix the problem of broken asylum system?
So I don't know that I actually or explicitly was trying to push the idea of a broken system. I was trying to suggest that there are a lot of problems. We have to acknowledge those problems and learn lessons from that. Now, in terms of figuring out something with the U.S., well, I think Bill C-12, as I tried to explain a few minutes ago, is proposing, I see as exceptional measures, and I think that makes sense if we accept the idea that we are in an exceptional situation. There's various problems relating to not just asylum questions, the immigration system more generally, and so I think this is a good try at actually bringing this. I think it signals very clearly that the government is trying to fix something. Now, politically, this is delicate in the sense that we don't want to insist too much on the how did we get there, yet we do want to learn the lessons, but we want to cooperate and figure out what are the mechanisms that can actually make sure that what is being proposed is charter compliant,
30 seconds.
is fair towards different migrants who are affected.
All right, thank you. So with that, what more should we be doing in C-12 then to under this burden sharing lens?
15 seconds.
It's on.
So I'm not sure I see more that can be done. I think it's more. It's what is actually being proposed, refined so that it's better.
Thank you so much, Mr. Professor Barusiski. Thank you. Next, we have 5 minutes for Mr. Zuberi. 6 minutes for Mr. Zuberi. I apologize.
Thank you, Madam Chair, and thank you to witnesses for being here today. I'm going to focus my questions on Ms. Tamadjidi, or as they say in French, Maître Tamadjidi. And with respect to, you mentioned a number of things in terms of some concrete suggestions on how C-12 can be adjusted, in your opinion, your expert opinion, from UNHCR. You say that that if PRA is used, that all claimants should have a hearing, number one. Number two, an appeal to the IRB. And number three, that moratoriums, you have a commentary on moratoriums in terms of those who are covered under that. Do you make those suggestions because of any international pacts or obligations that Canada has?
I make them because under international law, to assess whether someone is a refugee or not, they are required, or states are required to give them a right to be heard. If, for example, you're going to refuse someone, you should give them an opportunity to respond to your concerns. That is also in conformity with Canadian jurisprudence under the CIMM decision. So that's under the mandatory hearing requirement. Under the right to appeal as well, a full appeal right through the Refugee Appeal Division of the IRB is also a right that has been enshrined in international law and norms. And the moratorium countries, the reason we make that suggestion is that we have seen when Canada brought in amendments in 2019 where they did a similar thing and they gave PRA applications to certain ineligible persons as a first instance refugee status determination, that those countries weren't getting assessed. So they don't have an opportunity to get refugee protection, they don't have an opportunity to integrate, they don't have an opportunity to bring their family over, and arguably those countries that are under a suspension of removal have strong claims. They're coming from places like Afghanistan, Syria, Iraq, so those countries should have an opportunity to have their cases heard.
Thank you. And can you tell us which international pacts and covenants that Canada is a signatory of that you're referring to?
So there's the 1951 Refugee Convention and the optional protocol that Canada is a signatory to. There are also other international covenants like the International Covenant on Civil and Political Rights that Canada is also signatory to. And these covenants and conventions are ones that inform how an asylum system should be built and the rights that should be given to individuals when they come to claim in Canada.
Certainly. And Mr. Bellissimo, you mentioned that, I believe you mentioned that PRA wasn't designed for the way how we're using it right now or intending to use it right now. Do you have any suggestions on how, do you like these suggestions you heard just now in order to adapt it to the way in which we're trying to use it in this new system under C12?
So I think there's a couple of things there. One, we have to be careful we're not overcorrecting for a temporary intake. So refugee intake is down. The overall volume in Canada is down because of the measures the government has already taken. So the measures that my colleague is suggesting would go towards charter compliance. But in my view, you already have an expert tribunal that is performing those functions. And for the most part, if, as we talked about, with better management principles, better identifying of vulnerable claimants, and some of now the enhancements that Bill C-12 hands the IRB, no need to reinvent the wheel. Leave it where it is, because that's where I think we'll achieve the greatest efficiencies.
Better management. You speak about better management techniques with the existing system. Do you want to concretely outline what those are?
So I think Bill C-12 creates an informational journey now that is much stronger than what exists. So what the IRB is going to be receiving is stronger. If you leverage those expression of interest principles we talked about, the intake, the capacity management based on scheduling, no matter where a member might be in Canada, okay, you get that hearing going. You better identify vulnerable claimants so you triage those cases faster. And on the flip side, the cases that are weaker, you triage them out faster. I think with those tools, with what C-12 has equipped potentially, and again, I know the details will be in the regulations, but it sounds encouraging, I think you might see quite a positive outcome that I think CIMM should recommend that be seen and not overcorrect on a PRA system that you'll have to scale, you'll have to train officers, you have to create an independent unit. In my view, quite expensive, and you might create a larger backlog, and PRAs are already taking a long time. So if you're now going to place that administrative burden or capacity burden on PRA, I think we're working backwards.
30 seconds.
Sorry?
I'll leave 30 seconds to you.
Oh, okay. So as my colleague mentioned, a PRA has been designed for the back end of the process. I will say that there is always going to be a backlog in an asylum system. No asylum system is perfect and goes down to zero. it's a question of managing that backlog. And how do you manage that backlog? You create triaging systems, you create accelerated processes, and different ways of deciding a case that will help you figure out which ones can be decided faster and which ones require a bit more time to study.
Thank you so much, Ms. Tamjidi, and thank you, Mr. Zuberi. Next, we go to Monsieur Brunel-Duceppe, 6 minutes.
Merci.
Thank you very much, Madam Chair. I welcome the witnesses. Ms. Tamjidi, I'd like you to tell the committee, according to your analysis, whether C-12, if it's implemented as drafted, would comply with our signature of international agreements, and if so, how? Thank you for the question. I will answer in English if you'll allow me.
So I will note that there are regulations that have to be drafted that we have not seen. So it's hard to make a full assessment of the legislation without seeing those regulations. But the minimum standards we have outlined here today in terms of the amendments will bring the bill in line with international law and international norms regarding refugee status determination.
La même question pour vous.
Same question for you, Mr. Barotiski. Well, I think it's not the legislation as such that presents a problem. It's the way it'll be used. I think that's the issue, and we can't know right now. Having said that, there are powers that are very broad and that are granted to the minister and the governing council, and that could be worrisome. And that's why we're discussing parameters, how we can control what could be future decisions. I think that's the problem. In the future, how can we make sure that there are no violations potentially? Right now, I don't think we can say that there are amendments that do not respect our international obligations. Earlier, you talked about harmonizing with countries that we deal with, principally the USA. Now, having said that, if a country like the USA sees these measures for welcoming refugees drastically reduced, at that point, how could we harmonize with measures that may not respect international rules? The rules in the United States have not changed. The laws have not changed. Perhaps the policies have changed. The orders that are given by the White House have evolved in the past few months, of course. Of course, if legislation changes, if it becomes clear that the treatment of asylum seekers in the U.S. presents a lot of problems vis-à-vis international standards, then we'll have to rethink our cooperation with the U.S. That's part of our system in any event. We have to look at these things continuously to make sure whether we're participating in an agreement that complies with international rules. One thing we're told often is in public opinion, and my question is for you, but I'll share it with the other witnesses. Public opinion right now has a negative view of immigration in general, but asylum seekers in particular. It's very polarized, it's very politicized, it's instrumentalized for partisan reasons or electoral reasons. There was one measure that was announced by Minister Miller at the time with great fanfare with other ministers from provinces. They wanted to establish a committee to spread out asylum seekers according to demographic weight. We never heard anything more about it, but it was a proposal by provinces such as Ontario and Quebec that welcome many. Should this have been in C-12? Would this be defensible, distributing these asylum seekers regardless of where they enter?
Do distribute and relocate asylum seekers in different parts of the country, depending on their own policies. It is possible to do that in legislation and regulations or any other way that Canada decides to do so. For UNHCR, the important thing is that we would prefer that relocation be voluntary, and looks at other good practices that we see internationally. So, for example, in Mexico and Brazil, we're seeing relocation programs where they look at the employment needs of different parts of the country, pair asylum seekers and refugees up with employers for training, and relocate them based on that employment need. That way, individuals are able to integrate properly in a different part of the country while they go through their process, and able to settle better once they do get a decision on their case, if they get a positive decision.
A minute.
1 minute. I had written about this in La Presse about a year ago. To continue in the same vein as my colleague here, I'd say it is preferable but not necessary that transfers be voluntary. So I think we have to be realistic too. If we look at other arrangements in other countries. Now, having said that, your question is about whether this type of model should be introduced in the bill before us. My impression is that this is a political issue that can be negotiated separately. There's already something quite complicated in C12. It's not necessary to add something else that could be controversial politically, as you know. Okay, but having said that, my point is this might improve the public perception if there were provinces that welcome more people compared to their demographic weight, and others didn't welcome any, but that would not be welcome. That's another question entirely. Well, I agree with you completely. When it comes to public perception, so that people can understand that we're controlling this and managing this properly. Thank you very much.
I'm Monsieur Brunet-Duceppe. Okay, next we go to 5-minute rounds, and I think we start with Mr. Davies for 5 minutes.
Thank you, Madam Chair. Thank you for the witnesses. This has been very informative for me. In my riding in the Niagara region, we had, I can see by the reaction, you can tell where I'm going with this, the number of asylum seekers that took up a good portion of the hotels in Niagara Falls for 16 months. In fact, they took up the key hotels along the tourist area in the area and put a significant strain on not only the tourism sector, but the educational sector, the healthcare sector, and schools. The burden on the public education system was incredible. So I'm wondering if and this is a question for Ms. And I'm sorry if I don't pronounce your name correctly, Mr. Berczewski. Close, Berczewski. Thank you. Can you give me your opinion on what you think the impact of this, and would you agree that we cannot continue to operate in that sort of atmosphere in any circumstance in the future, regardless of what this bill does?
I think this is a good continuation of what Monsieur Brunet-Duceppe was talking about. We do need to think seriously about responsibility sharing within the Federation. So if a region is impacted disproportionately, or the government decides to resettle in certain areas, obviously that poses problems for the host community. Quebec had another kind of problem in that people were arriving initially there, but transferring without maybe consent or without sort of transferring to a particular region and creating problems in region is obviously a problem, and it affects public opinion. So I think part of the reason we're here is that we did not manage this politically very well. And so I don't think there's a legislative solution to this. It's a political problem that needs to be handled more effectively and more seriously, if we even took this seriously up to now.
So that leads me to the CBSA's recent departmental results found that the agency continued to miss key performance targets, and the lack of follow-through. The government's promise to hire 1,000 new CBS officers. I was speaking in the House today about the problem, the CBSA. 1,000 new officers is a drop in the bucket to what is actually needed across the board to manage not just asylum seekers, but border issues across the country. And I learned recently that, I'm not sure, I think it was Mr. Bellissimo said the IRB would be informed, a better informed intake process through parts of this legislation. But I just learned, for example, the CBSA reduced its detention capacity by over 40%. So now, people coming into the country seeking asylum, the CBSA is discouraging those that are deemed to be a difficult case to be put into the community. So that in and of itself creates another burden for the Canadian taxpayer. What do you think this would have, what impact would this have on the judicial process that these people may be going through, having been discharged from a detention center as an asylum seeker into the community? Does that complicate the process through which they would proceed in order to find a determination of admissibility? Actually, Ms. Timiju.
Yeah. Okay.
I'm sorry, I'm mispronouncing all the names today.
No worries. So I just want to highlight that the majority of asylum seekers are fleeing persecution. They are not the agents of persecution or subject to criminality. Less than 1% of foreign nationals are deemed inadmissible to Canada due to some kind of serious criminality. And asylum seekers make a very small proportion of that. So we recommend actually alternatives to detention during the asylum process because it enables asylum seekers to be able to participate in the asylum system much more effectively when they're not detained, to obtain documents and evidence of the persecution back home and be able to file that in a timely manner.
30 seconds.
Okay, if the CBSA has actually reduced its detention capacity, what, in your experience, would put somebody into a CBSA detention center?
It would be if it's flagged as a high-risk case where there's a security concern, which is a very, very small proportion of individuals that claim asylum would fit under that category.
Thank you, Mr. Davies. Thank you, Ms. Tamjidi. Okay, now we go for 5 minutes with Ms. Zaid.
Thank you, Chair. Thanks to the witnesses for coming today. My first question is for Madam Tamjidi. You have raised concerns in your opening remarks about the pre-removal risk assessment process and that the fact that it does not include an in-person hearing for the claimant to make their case. So could you discuss the difference between an in-person hearing and the one that is conducted on paper, and how the government could create a process that meets its desire for an efficient process while still meeting our obligations under international treaties and ensuring the procedural fairness for the claimant?
So a hearing gives a claimant an opportunity to respond to questions from an interviewer. It gives them an opportunity to validate their case, to give evidence. Their testimony is part of their evidence. Paper-based, you won't get that type of evidence. You will just get bits and pieces of paper from an asylum seeker that may or may not show what they're claiming and why they're fleeing that persecution. Oftentimes, it's important to remember asylum seekers don't have a lot of documentation either. They are fleeing situations where they were at risk, and they don't have time to pick up papers and leave. If you're fleeing a burning house, you don't have a lot of papers with you. So a hearing gives them an opportunity to give that in-person evidence under sworn testimony and gives them an opportunity to answer any concerns that a decision maker would have about their claim.
Can you give us some examples, like some refugees coming from countries where there is moratorium or they cannot go back? How would it affect not having the chance for the in-person hearing?
So they actually, people from moratorium countries would never even get an assessment of their refugee claim if this legislation remains as is. Because the pre-removal risk assessment was designed as a process to be done at the end of someone's journey in Canada, they will not get that pre-removal risk assessment unless they get a removal order. And because there's a suspension on removals from their country, they will never get that assessment. So that's why we're asking that those individuals be granted an exception to this legislation so they could have a chance to get a decision on the refugee claim. If they could get a decision on their refugee claim, then they will be able to apply for permanent residence if they are accepted, and then also include any family members that they wish to bring over to Canada so they could integrate and continue their lives.
You also mentioned in your opening remarks about the right to full appeal.
Yes.
Can you elaborate that, why that process is important?
Yes. So currently, as this legislation stands, the only appeal that someone would have would be at the federal court. And all the federal court will be doing is not reassessing the decision or the case, but looking whether that decision was reasonable. So they will not be interviewing the asylum seeker again. They will only look at paper-based arguments that are submitted by counsel. And if they're granted the right to do that judicial review, counsel will be able to make arguments in person. But a full appeal allows a decision maker to reevaluate the full case. And it allows the decision maker to also call a hearing if need be. And it's a good check on the pre-removal risk assessment process and also a good way to distribute efficiencies within the system. This way, you're not sending a huge amount of cases to the federal court, which already does get quite a bit of immigration-related cases, and you're ensuring that the Refugee Appeal Division, which does have capacity, can look at those appeals. Moreover, we recommend that people have a stay of removal when they are doing their first appeal after a first decision, so you are eliminating that risk of them being returned to persecution. Under this current legislation, that stay of removal does not exist for people going through a pre-removal risk assessment, and you risk a chance that you would have an erroneous decision made by a decision maker and you will send someone back to a country where they may face risk. It's better to have that full appeal right up at the front, and then the whole system will have efficiencies further down the road.
40 seconds.
Okay. So quickly, Canada is committed to having an orderly and managed immigration system. So what are the UNHCR's best practices or recommendations for managing sudden surges in asylum claims or the irregular border crossings in a manner that balances national security and system sustainability with our international humanitarian commitments?
I would say it's flexibility. Make sure that your systems are flexible, that they have different triaging models, that you are able to shift around also personnel to be able to address increases in volumes. And I will say this, I think Canada can manage this and has managed this in the past when we've seen increases at the border. They've been able to shift personnel from CBSA, for example, in the West Coast down to the East Coast to be able to manage those increases. And they've done contingency planning. Canada has done contingency planning to be able to respond to those increases. It includes the one-touch system as well, which I do think has been able to create a system that's a bit more flexible to ensure that they can manage an increase in claims. The majority of people going through the one-touch program are identified as low-risk cases. If there's criminality identified, they are not going through the one-touch program. They're going through a longer, more elaborate process at the border.
Thank you so much. That is time. Monsieur Brunel-Duceppe.
Mr. Brunel-Duceppe, 2.5 minutes. Always less for the bloc. Ms. Tamjadi, many migrant defense associations such as Amnesty International who tell us that if C-12 is applied as is, the rights of asylum seekers will be greatly diminished. What is the position of the UNHCR on that?
Really is a body that's there to look at the minimum standards for an asylum claim and for a refugee status determination system. Canada has long had a gold standard in their refugee status determination process. We often use Canada as an example to other countries in the world on how to properly assess whether someone is a refugee or not. For this legislation, the advice that I'm giving in terms of the recommendations that we are proposing to you today is to bring that legislation in line with the international minimum standards. Now, it's up to Canada to decide if they want to go beyond that or not.
La même question pour vous,
Same question for you, Mr. Baruchewski. Do you think that migrant defense groups who say that asylum seekers' rights will be greatly restrained if C-12 is passed? I have no doubt that associations that defend the rights of migrants will criticize any government proposal. These associations have done that in the past. That's their duty in a way. to criticize that, to make sure that standards are as high as possible. So to continue in the same vein as what was just said, Canada must decide where it wants to go with its standards. It's clear that we may reduce them or make decisions even more quickly. So that raises questions. There's no doubt that certain associations will oppose this, but they will oppose it in any event. Now, Mr. Bellissimo, if I have time, very quickly, with C12, won't we create a bottleneck at the Refugee Commission?
I think it is an overcorrection, and despite debating minimum or gold standards, ultimately you're taking legal and operational risks at a time when the federal court is incredibly backlogged. To me, it's an inopportune time to test something like this. I think it's best to talk about the efficiencies, and you already see all of the unintended consequences, moratorium countries, people in removal orders that'll now need to go for stays while they're waiting for to go to a PRA. So in my view, there are other ways to gate it based on the recommendations we made. No need to get into constitutional quagmires right now. Let's stay focused on processing efficiencies using the great parts of Bill 12 to move this all forward.
Thank you, Mr. Bellissimo. Merci, Monsieur Brunel.
Thank you, Mr. Brunel.
Time. I think you know that. Okay, so we are left with 3.5 minutes each for Mr. Menegakis, followed by Mr. Fragiscatos.
Well, first of all, thank you, all of you, for appearing before us today. Mr. Bardziski, I have a question for you. Do you believe that Bill C-12 will be challenged in the courts?
As I just said to Mr. Brunel Duceppe, I have no doubt that it will be challenged. Regardless of what you do, whatever amendments you're proposing, it will be challenged. There's no question in my mind.
You think it'll survive a court challenge?
That I'm not too sure about. We had situations like this in the past. I think of particularly the big decision from the Supreme Court on the Safe Third Country Agreement, where all the associations, all academics, everyone was trying to prepare big files, and we had a unanimous decision telling us that it is safe the U.S. is safe for asylum seekers.
Well, we are talking about people here and people that are fleeing persecution in other countries and so forth. We've heard testimony in this committee recently that will take almost 4 years to clear up the asylum backlog with no new additional applications, that's not reality. Every day we get applications. You think that C-12 will make the process, we've heard testimony also that'll make the process less fair, more costly, and longer. In your view, do you think this bill will clear the backlogs?
This is a question to me.
I'm asking you, Mr. Bardziski, yeah. They're talking about mass cancellations and all kinds of stuff here.
If we think that the situation is not that exceptional, then we shouldn't overcorrect. If we think that the country cannot normalize 6-digit numbers, 100,000 plus asylum seekers per year, if that's the new normal, I don't think it's a lot. It's actually very it stands out if we look at the last couple of decades in Canada. And I think it's very difficult to actually deal with that backlog with those kinds of numbers that I would say are uncomparable to all our ally states per capita. And actually, in absolute terms, they're getting close to the top.
We've also heard testimony about the one-touch system. And the one-touch system, Mr. Bardziski, as you know, if you pass the initial biometric and the questions you're asked, as you know, then the person has up to 45 days to fill in provide the rest of the information. Do you not think that this lends to the possibility of allowing people in that country that do have criminal backgrounds 45 days out into the country in our communities?
Of course, there's a risk there, and I would hope that the security screening is very serious.
And it would have to be, because if not, I can't imagine someone who's a criminal is going to magically say 30 days after they're here, oh, by the way, I'm a criminal, I should not be here.
That has always been the risk of an asylum system that is open, that you can have.
So the in-person that in-person interrogation is critically important up front, as opposed to just a one-touch system, just a fast track for expediency purposes, at the risk, of course, of allowing people in the country that shouldn't be here.
Thank you, Mr. Menegakis. Sorry, that's 3.5 minutes. I'm going to go to Mr. Zuberi for the last 3.5 minutes.
Thank you, Madam Chair. And I'll ask Ms. Tamjidi about vulnerable people. And we heard from a previous panel in terms of testimony that was given in the opening around vulnerable people and how there is uniqueness to them vis-a-vis C12. Do you want to share your opinions about the uniquenesses of vulnerable people and what are those categories, in your opinion, of vulnerability?
Individuals who are unable to understand the nature of the processes they're going through, minors, individuals who have suffered extreme trauma, when they're identified as vulnerable at the start of their process, the IRB, the Immigration Refugee Board, has put in place specific processes that would enable a better adjudication of those cases without re-traumatizing those individuals, ensuring that they have a chance to have their story heard. So those types of cases, because of the training of the IRB board members, it's good for the IRB to deal with them, given the complexity of those cases. And those cases could be granted an exception under this legislation if there's an amendment so that the IRB would handle those cases.
Interesting. So you're suggesting that to kick back vulnerable cases to the IRB instead of going... Okay. Do you want to outline what some potential vulnerable categories are that are not necessarily exhaustive?
Yeah. So, for example, someone who's a minor, I mean, not necessarily that they're vulnerable, but a minor could be handled by the IRB. They have processes in place for determining a case of a minor, especially an unaccompanied minor who's not coming with their parents. Individuals with mental health issues that are unable to understand the nature of their process that they're going through, who need a designated representative appointed to help them go through that process. The Immigration Refugee Board could handle those cases very well. Individuals who have severe post-traumatic stress disorder due to their past experiences, who have difficulty articulating their case, those individuals, if they are identified through a proper psychiatric report as being vulnerable, could be handled by the Immigration Refugee Board as well.
Change in country situation, does that, under international pacts and covenants, require a new evaluation of the situation? And how would that nexus with C12, how would that work?
So if there's a change in country circumstances, for example, someone who's been here on a student visa for 5 years and then war breaks out in their country, instead of channeling them through a pre-removal risk assessment, you could grant an exception in this legislation and channel them to the IRB to deal with their cases, so they get a chance to appear before the specialized tribunal. We've seen that, for example, in the case of Ukrainians. They may have been here for a couple of years, then war broke out and they wanted to make an asylum claim. So that's the type of exception that we could look at for individuals if there's a change in circumstances.
Thank you.
Thank you.
Thank you so much. I want to say a huge thanks to our three witnesses. Not only did you provide important testimony today, but I think very thoughtful and excellent recommendations, which will be taken into consideration. So thanks to all three of you. And apologies, with my last name, you would think I would say everybody's last name perfectly, but I'm as bad as everybody else. So I want to say thanks to all of you. But before, colleagues, hold on, just two quick things just to mention. Our last day for the study is going to be on Thursday. We are officials coming back for the first hour. Second hour is we are going to be looking at the recommendations. And we do have approval to extend up to half an hour. So we do have translation and everything set up. Peter, Mr. Fredescatos, if you could just wait. I'm just finishing up for Thursday. And then just to let everybody know, next Tuesday we are scheduled to go back to the massive immigration study that we have. Just wanted to make sure everybody's on the same track for that. So with that, nothing else on our agenda. We are adjourned. Yeah, if we don't need it, we don't have to.